we're going to talk about privilege issues mostly for contract drafting and negotiating. So, whether you're in house or outside counsel, when you're advising your clients, internal or external, on contract terms and negotiation, you're frequently providing a mix of legal and business advice in the same communication. What is attorney-client privilege? It's a legal fiction, really. It's designed to encourage free communication between an attorney and their client. And you really have to understand how it is created and how it is destroyed. So, how is it created? It has to be generally in the United States a communication between an attorney and a client seeking legal advice with the understanding that the communication is going to be kept confidential. So if you meet all those elements, then you have created an attorney client privilege communication that is protected from discovery in any future lawsuits. But in the United States, there are differences in the state courts and even in the federal courts on who is within the realm, which communications with which parties, even your own business clients, fall within the attorney client privilege. For example, I have a lot of cases in Illinois and I have a lot of cases in Georgia, and their privilege tests are about as different as they can be. So Illinois has something called the control group test, which is really restrictive. And the control group test basically says an attorney can only have a privileged communication with the company's control group. The control group consists of top management who have responsibility for making final decisions, or they are necessary advisors whose opinions or advice form the basis for the top management decisions. So communications with frontline employees, maybe those who don't have a managerial or supervisor status, those who maybe do not advise top management, you may be communicating with them about a certain term, but your communications with them in Illinois may not be privileged. So you need to be aware of that restriction. Contrast that to Georgia, where any communication with anybody for the purpose of seeking or providing legal advice with understanding that is going to be kept confidential creates attorney-client privilege. You can feel free to have that conversation with a frontline employee, someone who has no direct influence over upper management. And as long as you are providing legal advice, or it's for the purpose of providing legal advice, and that communication is kept confidential, you've created attorney-client privilege. So you do have to understand what is the specific test in the jurisdiction that will likely interpret the contract in the event there is dispute about a term, and make sure that you follow those guidelines in that state to create your privilege. In the US, you also have to be aware that state law on privilege can differ from federal law as well. So there's currently a split in federal circuits where dual purpose communications, which involve legal and business advice, are involved. There are probably more tests than what I'm going to share with you. So do your own research. There's a primary purpose test where the courts look at whether the primary purpose of the communication is to give or receive legal advice as opposed to business advice. The implication is that a communication can only have a single primary purpose. And if the primary purpose is to provide business advice, even if there's a little bit of legal advice in there under that test, there's no privilege. So you would have to hand that communication over. There's also the because of test in federal circuit, which is much broader. That test says if a dual purpose communication was made because of the need to give or receive legal advice, it is privilege. So what do you do? And I think the best advice here to give to your business folks is to say, if you have an issue, if you want to talk through something that's a little bit sensitive, whether it's business advice or legal advice, let's talk on the phone. Let's not create a string of email communications or text communications talking about complex or nuanced issues or speculating about this risk versus that risk. Let's schedule a meeting or let's pick up the phone and talk through it so that we can reach an understanding, get to a place we both feel comfortable about, but we don't have written attorney client privilege communications that could potentially have to be handed over. And then you, as the attorney, can document what's necessary to memorialize the conversation, perhaps the conclusion that was reached, and keep that in a file. So that does limit the risk that your communication is subject to disclosure when you're not sure what the applicable law is in regarding the contract provision that you're working on.